This conference is now being recorded.
Good afternoon. Welcome to the New York State ASBO webinar, The Claims Process, Getting Back What You Lost in conjunction with NYSER. Our speakers for today are Mike Coffey and Ralph Falcone from NYSER. If you have a question at any time for either Mike or Ron, you have two options. You can use the chat window located at the right-hand side of your screen, or if you want to talk to them over the phone, you can hit 7 pounds. That'll notify me that you have a question, and I'll put you right through. So Mike, Ron, it's all you.
Okay, thank you very much, Matt. The topic for today is the claims process, getting back what you lost. Kind of geared that towards first-party property losses to your building and contents. Moving on to the first slide, what should you do after a property loss? That kind of depends on the situation that you have. In the event of, an emergency such as a fire or burglary, obviously one of the first things you should do is contact the proper emergency personnel. Just a little, common sense. Depending on your situation, you need to call the proper authorities first. Contact your insurance company as soon as reasonably possible. Try to have, if they have it, try to have the 24-hour emergency contact number available prior to a loss.
And I'm sorry, this is Ron Falcone speaking. What you should remember is most of your obligations are actually spelled out in whether it be a property policy or a general liability policy. Some of what Mike has just discussed is literally part of the insurance contract, where you have to take reasonable steps to protect your property and report it promptly. Naturally, all of this is an effort just to try to minimize the damage and get you back up and running in the shortest possible time.
After contacting the proper authorities or your insurance company, you should try to take all reasonable steps to protect the covered property from further damage. This could include cleaning up standing water or closing up any openings in the building, whether this is from a fire loss in which a roof is either burnt or cut open by the fire department, or in some instances where a car literally drives into a building and creates an opening in the exterior wall. So you want to try to close that up as quickly as possible. In speaking with the insurance company initially, they can provide some guidance or assistance in who to contact for that, or if your staff is capable of doing the cleanup or board up, by all means, try to do that as quickly as possible.
Remember, that is an expense that's covered under your insurance policy. Emergency board-up repairs are very typical.
If emergency repairs are necessary, retain the materials that are replaced for inspection and examination. In the case of water escaping from a plumbing system, emergency repairs may be necessary to stop that flow of water and to maintain your normal operations at that particular time. You can have the defective parts retained for examination by an expert to determine the cause of the failure. Sometimes it's not initially known what the cause was, particularly in, for example, a plumbing loss. Could be a pipe freeze, could be improper installation, could be defective materials. So we want to try to obviously stop the flow of water if emergency repairs are necessary, but also retain those parts that are being replaced for examination. For a fire loss, do not disturb the area of origin or the room involved until an investigation is completed by the fire department personnel and the insurance company. Allow the insurance company to conduct their investigation regarding the cause of the loss. before anything is done, just going back to the prior slide, do not disturb the area of origin or the room involved. A lot of what takes place in the investigation is how the room exists immediately after the loss. In the case of a fire, it could be what materials appear to be in the area of origin, what the burn pattern may be on a wall or a floor, burn marks in general. If it originated on a floor, is the floor burnt? If not, well, then it would appear to have maybe started higher than that. So you want to try to preserve it as best as possible. If a restoration company is brought in, limit that area or room until the fire marshal or fire department does their investigation and the insurance company has their own fire investigator complete their investigation. Determining the cause of loss and who may have contributed to it is critical as far as possible subrogation recovery. In some instances, there may be a definitive cause of loss proven, but sometimes it's not. And when it's not obvious, what they try to do is almost like a process of elimination and determining, well, what couldn't it have been? What could it not have been? And go from there. The investigation itself will identify any evidence to be secured by an insurance company representative. This is a photo of a boiler room, the boiler and its burner, an example of identifying evidence that is being investigated. The investigator taped off the area with yellow tape and also put a posted on the or notice on the boiler itself, so warning people not to disturb the area or touch this as it's considered evidence. Tampering or discarding of evidence will diminish the insurance carrier's chances for recovery from a potential negligent party. Regarding a potential negligent party, many times it involves a contractor performing or having performed work on the building. As part of what the insured needs to do is to locate any documentation related to any work by a particular contractor that may have contributed to the loss. Documents could be work orders, work tickets, invoices, also a certificate of insurance for the contractor. For theft or burglary, limit access to the scene until police detectives complete their crime scene investigation. You really don't want to alter any clues that may be available, such as fingerprints or even footprints. I've had situations where they're able to, they have something to go by at least, whether it's footprints in on the floor or on a roof. I've seen perpetrators access a building by way of the roof, and they leave evidence behind, whether it's tools, footprints, or anything. So you want to try to keep the area intact until the police do their proper investigation. And you also want to provide any access to surveillance video that you may have for the building. And it may not necessarily be for the area that something was stolen from, but also surrounding the building, because they can use that video to see if anybody is coming or going to the building, not just into a room where something may have been stolen.
There's some things that we may consider incidental, a fire investigator might consider critical. We had a recent large, or Mike handled a recent large fire loss, and the expert for the other side, the contractor who we thought was responsible for originating the fire, his company actually went out and were collecting cigarette filters outside the facility door just to insinuate that the facility personnel were smoking outside the area of origin just giving somebody at the end, possibly a jury, the opportunity to see that there may be another alternative. So even cigarette butts outside by a garbage dumpster was considered as evidence.
So you really want to keep the area intact as a whole until the investigator or investigators give you clearance to occupy the space or to do any necessary cleanup.
It also hurts as far as the restoration time goes. But believe it or not, there's plenty that you can do in the event of a serious loss to get the ball rolling that still doesn't impact on the origin of the fire. There are plenty of ancillary rooms and ancillary work that needs to be done. So although it might slow it down, there is still plenty to do.
Depending on the circumstances, address temporary relocation needs. Have a contingency plan prior to a loss. Relocation could involve a few classrooms or offices or an entire building. Review the situation with the insurance representative, restoration contractor, your architect or engineer to determine what the anticipated downtime may be for a particular area. Or also speak with the contractor's ability to restore accessibility. As Ron was getting to, a fire in one room could have smoke effects to an entire building. How quickly can those smoke effects be cleaned to make those rooms available for use? The room where the fire originated may be down for weeks, but those other rooms that may have just had smoke effects, they can be up and running within a couple of days, and limiting the amount of relocation that you need to do.
That is also an expense that's covered under your insurance policy, which is a cost to continue your operations is part of your coverage.
Okay, and now your damages. For damaged property, it must be assessed to determine if repair or replacement is necessary. And you must separate the damage from the undamaged property to the extent that it is possible. That's part of the insurance company's job, and or their assigning of an independent adjuster to assess the damaged property. So they would work with you on reviewing that, may ask you to have certain property evaluated, or if necessary, we may bring in the insurance company may request a consultant be brought in to determine the extent of damage and whether something can be repaired or not. Prepare an itemized list of damaged or stolen property. As far as schools are concerned, my suggestion is to utilize staff with knowledge of the damaged property. If a loss involves several classrooms, enlist the teachers in each of the classrooms to provide an inventory so any one individual is not overburdened with trying to come up with this inventory. We've had several large losses, and we find that, and I think the schools that have had those losses find it helpful to enlist various personnel to help come up with their list of damages, particularly, obviously, on a large loss.
You may have also had a recent inventory done where all of your contents, at least of a certain value, are already documented. So if a room or a portion of a building is considered a total loss, assuming everything within that area is also a total loss, you should be able to come up with your last inventory.
In the case of a contents loss, this is a photo of a classroom that was part of a large fire. As you can see, everything's a total loss in this room. You want to complete an itemized list of the contents as best you can, identifying the make, model, age, and the original cost of the items. Again, utilizing the staff with knowledge of the damaged property, providing as much information as possible to assist the assessment of the loss. I want to provide proof of ownership, whether it be purchase orders, receipts, owner's manuals, photographs. With schools, I find that they're pretty diligent in maintaining records on what they have, down to serial numbers. So with schools, we don't seem to have too much of an issue with that. Secure replacement quotes for the property. A lot of times school districts, they have particular vendors that they purchase from, whether it be by contract or just past utilization. And the districts find that this particular vendor provides the best quote, best price. We would just ask you to get those quotes for us to review and determine what else may be needed. If the exact item is not available, secure a quote for one of like kind and quality. While your policy may have replacement cost coverage, the replacement typically is for one of like and kind, not necessarily a brand new item. Depending on the type of item, brand new may be the only thing available. But we do look to replace it as close to what you had as possible. In the case of a building loss, this is a photo of the building where that classroom that we showed earlier, significant fire loss at this particular school. Try to have building plans or as-built available for review. That will help in expediting the assessment and identifying the scope of repair on small losses and large losses.
In the event of a significant loss, we found that your school architect, which in fact is the next slide, really can be critical and assist greatly in determining what was there before and what can go back. Typically, what you're entitled to is what you had, but naturally it goes back based on today's standards. So you are left with something better, but it's your architect that aids and assists in complying with current Department of Ed codes.
Yeah, your architect and engineer, if you've been utilizing them for a while, many times are most familiar with the construction of the building and, again, can help expedite the assessment of the damages. Attempt to mitigate your damages, and if need be, contact an expert. This is a photo of a gymnasium wood floor. I show this because these are one of our largest losses if they are not addressed quickly enough. I would suggest contacting a flooring expert or restoration contractor, someone who can take moisture readings and investigate whether there's water trapped underneath the floor. Because if you do not do that, and there is water trapped underneath the floor, you'll know it in about a week when the floor starts buckling. And that very well may result in the replacement of the entire floor when, if moisture readings or the proper investigation was done initially, could have just limited it to drying of the floor or minimal repairs to that floor.
We've seen repairs where what they might do is come in and remove all the perimeter boards of your flooring because naturally when the floor is wet and it absorbs moisture, it expands, which is why it starts to buckle and cup. So what they do is they remove the perimeter, giving it room to expand without cupping and then come in and perform the repairs around the perimeter. So what you've done is you've saved the gym floor, which is what, Mike, about an average of 160 or?
Yeah, anywhere from 100,000 to could be over 200,000, depending on the size of the floor. $200,000. I would suggest or impress upon your facilities people to let you know of any type of water incident involving a wood floor. Many times they'll have a water incident, they'll clean it up, thinking everything's okay, not realizing that water may have gotten underneath the floor. And then you wind up with cupping or buckling of the floor or even mold development underneath the floor.
It really is probably one of the most overlooked causes of loss, only because everybody thinks that we can take care of it ourselves until a week later when you realize that you really do have a problem. It's not necessarily what you saw. You may have seen 2 inches of water above the floor, but it's everything that's going on underneath it that you cannot see that needs to be attended to.
Any current building code requirements should be identified and costs assessed. This is typically done by your architect or engineer, also reviewed by the contractor and the insurance company or their adjuster. What you'll want to do is get an agreed scope of repair with the insurance representative. Again, that could be an independent adjuster hired by the insurance company. An adjuster may complete a repair estimate based on his own inspection, utilizing the building plans if necessary, or he may even retain an engineering or building consultant to help with that assessment. It very well depends on how complex the loss is or how complex the building is. Secure multiple quotes for the agreed-upon scope of repair. In many situations, the school district will have to go out to bid, and what the insurance company is looking for are the bids to be based on the agreed scope of repair. And hopefully that agreed scope is obviously reached sooner rather than later.
But remember, in the event of an emergency situation, you typically avoid going out for quotes. We'll actually come in and try to control the scene as long as it's agreeable to you. Again, it's our objective to get you up and running in the shortest amount of downtime. When you go out for quotes, I'm sure you realize by now that you are greatly delaying any opportunity for work to be done. The law does say that in the event of an emergency, you avoid the quote process or the bid process. You don't have to go out to bids.
In some instances, the insurance representative can secure an agreed price with a particular contractor. If you have a contractor of choice, if they can get an agreed scope, very well can get an agreed price that's fair and reasonable for the work that's necessary. That helps expedite the repairs and getting you back up and running. Some insurance carriers want to see a final invoice for the repairs. This may be necessary to recover your damages in full, less any deductible that you may have. Replacement cost value versus actual cash value. Loss or damages are assessed for property of like kind and quality. The assessment is subject to depreciation. And the depreciation can be based on the type of the property itself, the age, and the amount of use that particular item gets. So these are factors as far as type of property, age, and use that go into determining how much depreciation may apply. Depending on the policy coverage that you have and the property involved, you may be entitled to recovery of depreciation when the property is replaced. This is also referred to as recoverable depreciation or replacement holdback. Depending on the conditions of the insurance policy, you may have to inform your carrier of your intent to replace or have actually replaced the property within a certain period of time. Many policies, from what I've seen, indicate that you must inform the carrier of your intent to replace within 180 days of the loss. Typically, the policy will consider the cost of repair or replacement at the time of the loss, or at a point in which repairs could commence. If you decide to wait a year, or if you inform the insurance company within 180 days that you intend to replace the property, but you wait a year to do so, well, probably the cost of that work or item has gone up in that year. So the insurance company technically owes for the time that the loss occurred. Extra expense. This is an additional expense incurred over and above your normal expenses, which are necessary to avoid or minimize the suspension of business and return to normal operations after a covered loss to covered property. This can include additional security on site, temporary heating or electrical services, relocation costs until the damaged building could be reoccupied. A relocation cost can include such things as a temporary trailer that may be brought in on site, trailer or trailers, depending on how much space is needed, busing students to another location, or outfitting a part of the building to address your needs. I've had instances where the technology room has a significant loss, whether water or fire, but the rest of the building is fine. What they were able to do is run the necessary wiring to another part of the building and set up their IT operations in another part of the building as opposed to relocating it elsewhere. This is a photo of a temporary boiler. This was brought in on a trailer to provide heat and hot water to a building after a boiler room fire. So there are things out there to help you operate something as large as a boiler on wheels, so to speak. These expenses must be necessary and reasonable. And I would suggest reviewing the parameters of covered expenses based on a particular situation with the insurance representative. You don't want to be incurring things that the insurance company comes back and says, well, why did you do that? It wasn't necessary. Make sure you touch upon it beforehand. Extra expense will only be considered for the time reasonably necessary to repair or replace the lost or damaged property. Provide documentation for expenses incurred. You want to keep track of everything that you're incurring, whether it be receipts, purchase orders, staff overtime. Want to keep track of all these things that may, if you don't know if it's considered as an extra expense, have the insurance company review it. Perhaps it is an extra expense, or there's something that they would consider. You'll need to provide documentation for your normal operating expenses. Your extra expense claim will be offset by what your normal operating expenses would have been. So while extra expense is covered, it is actually reduced by the amount of what you normally would have incurred if the loss had not happened.
I'll give you an example of that. We had an elementary school that dispersed its students to other school locations within the district. Now, they've always provided lunch at the location that was the cause of the loss at that fire-damaged building, but now they have to provide lunch to these additional children that were dispersed throughout the district, and there was an additional expense primarily in the transportation of food products to the other locations. So you always had the expense of providing lunch, now you had the extra expense in transportation. So it's not just the expense of lunch, because that's an expense that you always had.
As the slide indicated earlier, extra expense is over and above your normal operating expenses. Subrogation. If a negligent party is identified, the insurance carrier will pursue that party for recovery of damages, including the insured's deductible. As I previously indicated, have any contract information available for the insurance carrier's review. The extent of subrogation recovery is based on the actual cash value of the property and the percent of negligence. If you make a liability claim against someone else's insurance policy, all that they're entitled to reimburse you for is the actual cash value. Basically means that they're taking depreciation into account. They don't owe you for new. That's what your own insurance policy hopefully offers. The extent of subrogation recovery may also depend on the cost to pursue such recovery, or even how strong the case may be. In some instances, we don't have a smoking gun, so to speak, as to why the particular loss happened, but we have a pretty good idea. If we feel that it's not strong enough, we may want to recover as much as we can from the other carrier or the other party for a settlement. The insured's deductible recovery is prorated based on the total amount of recovery compared to the gross loss after any legal expenses are deducted from that recovery. So to get back what you lost, you must prove your property loss to the insurance company by providing as much information as possible. As you can see from this photo, this school provided everything that was necessary to get back everything that they had in the building. Joking aside, a good insurance company will work with the school district to get them back up and running as quickly as possible. We understand the pressures that schools are under, so we try to make it as painless as possible with as little inconvenience as possible. Obviously, it all depends on the circumstances. Sometimes it's just unavoidable. So you want to cooperate with your insurance company and provide as much information as possible to help in the assessment of the loss to hopefully recoup everything that you have lost as a result of the claim.
We hope that maybe anybody have any questions in regards to property claims.
If you have any questions, you can hit 7# on your phone. I'll put you right through.
Okay.
Yep, go ahead.
Mike, we can move on to casualty claim management. Michael discussed property claims, which unfortunately we're all probably familiar with. Casualty claims, hopefully nobody's too familiar with. Before a casualty claim ever really results in a claim, what it is, it's an incident. something occurred on your premises where somebody may have got injured, somebody's reputation may have got injured, and it's important that we take steps at that incident stage because many incidents can result in a claim. For one company, we insured a supermarket, and shoppers who slipped and fell on the floor pursued claims, and when questioned what was the driving factor, other than an attorney, it typically was the attitude of the store personnel. Nobody wants to be involved. People turned their back on me. People walked away. When something happens on your property, again, we're educational institutions. Let's not be like supermarkets. Most of you aren't. But show a little empathy, show some care, call for medical assistance, secure the area in anticipation of a claim, which many times depends upon the severity of an injury. Somebody is laying on the floor with a fractured leg. You can obviously tell that it's fractured. In today's society, you can reasonably assume that that is an event that may result in a claim. Preserve the area, and let's try to get the condition as it existed when that person fell. The first person on the scene is the most critical person. Most insureds today have some form of a camera, or everybody's cell phone is equipped with a camera. There is nothing like a photograph of the area depicting what it was like at the time that person fell or was injured by whatever means. Incident reports. When somebody completes one, please make sure your incident report does not already have pre-printed leading questions such as what was the defect that caused the fall or the injury. Because right there you are assuming or leading somebody to presume that there was a defect in the first place. Witnesses, whether it be passerbys or personnel or students, are critical. Much of this information in a year from now is forgotten. People don't recall, or again, unfortunately, sometimes people, especially students and parents, don't want to be involved. When in doubt, you can always call your insurance company and let them know that there was an event that may give rise to a claim in the future. Remember that, again, much like your property policy, your obligations are also contained in the beginning of your liability policy, in the beginning of that casualty section of your policy. Insured's duties, that's to notify us as soon as reasonable of an incident that may give rise to a claim. When in doubt, call. Protect yourself. For municipal institutions, which most school districts are, naturally there are many other municipal institutions, the actual claim itself will be triggered by the service of that notice of claim. Notice of claim is a very specific document telling exactly who, what, when, and where. And even more information, the nature of the injury. That notice of claim is supposed to be served upon a designated individual, but you will find that claimants and their attorneys many times just serve it on whoever will accept it. Within your organization, you should have a person designated to be the one to accept a notice of claim where it could be properly recorded, how it was served, who it was served on, and when it was served. Everything naturally should be date stamped. Because, again, a notice of claim is a legal document that comes with legal requirements and legal obligations. It also affords us opportunities. When a notice of claim is served, it affords us the opportunity to have a claimant-only deposition where we hear directly from the claimant what their story, what their claim is going to be about when and if it goes into the litigation process. Again, your casualty claims management, the policy does, again, list your responsibilities. At the same time, it also has what our obligations are. We will provide you with an attorney at our expense. We will prepare your staff in the event that they need to give depositions themselves. And we, again, are the entity who will, in the event of a liability or negligence, make that claimant whole. Very few casualty policies have liability deductibles, meaning 100% of your defense and indemnification is paid by your insurance company. Specific to automobile accidents, always, please, in the event of any bodily injury or property damage in excess of $1,000. Nobody is an appraiser. Take a guess. If it looks like a lot of damage, assume it's in excess of $1,000. Anybody is injured, you do have an obligation to call the police, but the obligation aside, it's just to your best interest to do so also. Within your district, again, you should have a contact person. Typically, in the event of an auto accident, I'm sure you realize it's somebody from your transportation department. Assume no obligation. Do not tell anybody that, please, don't worry about it, we're going to pay for this. You might not have any legal obligation to do so, and by volunteering to do so, believe me when I tell you, it may not create any goodwill at all, and if somebody intends on commencing a legal action against you, they will, no matter what you offer to do anyway. Naturally, secure any information that you can at the scene, specifically drivers and passengers, and by now I'm sure everybody is familiar with the MV-104, the document that when completed, just provides a wealth of information for us to assist in the defense of a claim against you. Also, you know, prior to the litigation process or prior to assigning counsel, your insurance company, as we do, will probably assign an investigator to go out and secure information, take statements from witnesses, photographs of the accident scene, if it's an intersection or if it's a fall from playground, and gather all necessary information to assist in the defense of that claim. An insurance company, your insurance company, is only as good and only as successful as the amount of information and quality of the information that you provide. It is a joint effort, and that cooperation just leads to successful defense of claims, which in the end results in a better loss experience for you. Thank you. And if anybody has any questions, we'd love to entertain them.
We have no questions currently, but if anyone has any questions, again, please hit 7# on your phone. I'll put you right through to Mike or on. Now's the time. You've got some experts from NYSER with you, so don't be shy. Hit 7#. Hey guys, we've got no questions.
All right.
Okay, thank you all very much for your time. I hope you found it useful.
Thank you.
Everyone, thank you. Mike, Ron, and everyone at NYSER, thank you all very, very much. And our final webinar in this series, What to Do in a Crisis, is on track for Monday the 21st. So I'll see you all then. Thank you very much.
Thank you.